Naririnig naman po ka ng malinaw, ng maayos. Okay. Sige po, mag-i-start na po ako. Ako po yung magdi-discuss ng Section 6 po para po sa ating Judiciary Department or Judiciary Branch.
What's your name?
Okay, so Section 6, I am Remy Victoria Canindo po. Remy po.
Okay. The class president?
Yes po.
Okay, you proceed.
Okay, good afternoon po. Ang discuss ko po ay Section 6. Sa Section 6 po, ini-state ng ating 1987 Constitution na the Supreme Court shall have administrative supervision over all courts and the personnel thereof. So administrative supervision po over who? Yung mga lower collegiate courts po and lower courts na nakikita niyo po sa baba. Sinasabi po na isa po ito sa mga malaking changes na pinakilala ng ating 1987 Constitution compare sa ating mga past constitution sa ating judicial system. Noon po kasi ang mga lower courts po were subject to the administrative supervision po of the President, who exercised it through the Department of Justice and headed by its Secretary of Justice. So nung frename po ang ating 1987 Constitution, kinikilala po nila na it was natural daw po na yung mga decisions po taken sometimes heavily influenced po by political consideration. Kaya po nagkaroon po ng changes at ang changes pong ito ay nagre-remove po, kinikilala po nila na magre-remove ng possible executive intervention pagdating po sa affairs ng courts and sa administration of justice. Yung formal transfer po ng yung formal transfer po from the Department of Justice to the Supreme Court ay effected po ng Presidential Decree number 185 at ito po ay inissued noong May 9 by the Supreme Court through an office headed by a court administrator appointed by the Chief of Justice. So ayun nga, katulad po na sinabi ko kanina, itong change po rin i-remove po yung possible executive intervention sa affairs po ng courts and sa administration po of justice. Ito po yung decree. So ang question po, bakit hindi nga ba pwedeng makailam ang executive branch pagdating sa affairs ng courts? Babalik po tayo dun sa pinag-uusapan po natin dati na doctrine po ng co-equal branch or separation of powers, kung saan ang bawat isa ay hindi pwedeng makontrol or masubject sa influence ng other branches nila. Yeah. Next po, wait lang. Yan, next po naman, punta naman po tayo sa Section 7. Sa Section 7 naman po, dito din i-discuss yung ano nga ba yung mga qualifications. If gusto mo, qualifications po ng members ng Supreme Court. Okay, so for the qualifications po ng members of the Supreme Court or any collegiate court, so number 1, a member based po sa Section 7, a member of the Supreme Court must be natural born of the Philippines. Katulad po ng pinag-usapan natin nakaraan, pag sinabi pong natural born, hindi po pwede na, dapat po both of parents mo po ay Filipino citizen. Hindi po pwede ang naturalized citizen kapag gusto pong maging member ng Supreme Court. So, saan ka man po pinanganak, saan ka man po ginawa, basta po Filipino ang mga magulang mo, ikaw po ay natural-born Filipino. Kapag dumaan ka po sa process naturalization, hindi ka po natural-born citizen of the Philippines. So ayun po, number 1, ang requirement po dapat natural-born citizen para maging member of the Supreme Court or any lower collegiate court. Pangalawa po, kayo po ay dapat at least 40 years of age. Next po, dapat po at least may 15 years or more na dapat naging judge ka po ng lower court or nag-engage ka po sa practice of law in the Philippines. And next po, you must be a person, ito po yung requirement na hinihingi ng Constitution, you must be a person of proven competence, integrity, probity, and independence. So yung qualifications po ng any member of the lower collegiate court ay na kinocompose po ng isang judge. Ito po yung mga collegiate courts na sinasabi natin kanina, yung Sandiganbayan, Court of Appeal, Court of Tax Appeals. So yung qualifications po dito sa tatlong collegiate courts na to, pwede po siyang i-prescribe ng Congress, pero criteria po na sinasabi dito, yung competence, integrity, probity, and independence, ito po ay tumutukoy sa qualities of the mind and spirit na kinikilala po ng ating constitution na every judiciary must possess. No, it is intended po bilang guide dun po sa recommending body na i-discuss po natin mamaya, ang Judicial Bar Council, at ng appointing authority, which is the President, and nagsaserve din po as a reminder po sa appointee kung sino man po yung maa-appoint. No? Ito daw po yung mga qualities na dapat nilang i-possess, and these qualities are indispensable. Kasi sinasabi po nila na kinikilala na ang justice system po, any kind of system, it is good or it is as bad as its judges. So kung hindi po maganda yung ma-appoint ng mga judges, hindi rin po magiging magandang takbo ng justice system. So ito po yung parang principle po itong last requirement. Next po. Next po naman, magkakaroon po tayo ng question. Meron ba or pwede bang i-alter ng Congress ang qualifications po ng Justice of the Supreme Court? So the answer is no po. Hindi po pwedeng, ang Congress po, hindi po siya empowered to increase or decrease yung qualifications ng Justices of the Supreme Court na binigay ng Constitution. Although hindi naman po sila prohibited na mag-prescribe ng disqualifications as long as yung disqualifications na pong ito, halimbawa po nito yung conviction of crime ng isang justice ng Supreme Court, as long as they are relevant po dun sa nature and functions po ng office nila. Next po. Okay, doon naman po tayo pumunta sa qualification of judges and lower courts. So, sa qualifications po ng judges and lower courts, una-una, it must be constitutional. Pag sinabi pong dapat constitutional, ang judges po ng lower courts dapat po citizen, Filipino citizen. Although kapag sa mga lower courts po, hindi naman na po kailangan, unlike sa Supreme Courts and collegiate courts, hindi naman po requirement na kailangan natural born. So, inilagay po tong requirement na to for the lower courts, judges of the lower courts, para daw po mapigilan yung pagturing sa mga naturalized citizen as second-class citizens. Although po kasi in the case po ng yung mga matataas na korte, yung natural born po na requirement ay naiiwan pa rin. Next po na requirement, dapat po member of the Philippine Bar. When you said member of the Philippine Bar, hindi lang dapat nakapagtapos ng law school, hindi lang dapat nakapasa ng bar, kailangan po nakapirma po doon sa role of attorney sa Supreme Court bago po maging judge po ng isang lower court. O, dapat inscribe po sila sa role of attorneys. And next po, dapat po yung same qualities kanina ng mind and spirit, he must be a person of proven competence, integrity, probity, and independence. So these things na binanggit po sa task are all above minimal qualifications po, something po na hindi pwedeng i-alter ng Congress. Next po. Sunod naman po, dapat po ito po ay statutory. Ibig sabihin po nito, yung Congress po kasi ay binigyan ng authority to prescribe additional qualifications for judges ng lower courts. Lower courts na po ito, unlike po nung sa Supreme Courts and other collegiate courts. Yung statutory qualifications po ay makikita po natin sa isang law na nakikita niyo po sa inyong mga screen, yung Batasang Pangbansa number 129. Yan, dyan niyo po makikita yung mga prescribed additional qualifications for judges of lower courts. Yan, next po. Yan. Pagdating naman po sa administration of justice, pinapaalala po dito yung tatlo. No? Makikita po natin na unang-una by nature. Sinasabi po kasi na compare daw po sa ibang public functions and duties, yung dispensing po ng justice ay kinikilala as something na extremely important for it is both delicate and singular. Diba? To sit in judgment over one's fellow men, to pass upon their controversies na nag-i-involve po ng rights, ng fortune, and in criminal cases, diba, nagde-determine ng innocence and guilt, na yung decisions po ay nag-i-involve ng freedom, ng honor, ng buhay, ay hindi po siya ordinary business. So inirecognize po ito na serious task at may grave responsibility with far-reaching effects. So dinedetermine po na dapat yung character po and fitness ng judges kinikilala ng Constitution na dapat fit. No, yung possession po kasi ng legal qualification prescribed for the appointment to the judiciary and existence of constitutional safeguards na binanggit ko po kanina ay nandoon para protektahan ang judicial independence. Although they are not assurance po na yung appointee po ay talagang impartially magiging free from all outside pressure and influence, but at least meron po tayong mga specific qualification to safeguard those four important things. Yung framers po ng Constitution natin, gusto po kasi nila, kaya nilagay po itong mga qualifications na ito na is po nila na yung person po na mag-exercise ng judicial function must be absolutely impartial and independent-minded so that parties before him can obtain and receive justice based only on merit of their claims. Next po, yung pag-administer po ng justice, kinikilala din po na dapat meeting and nagmi-meet po sa exacting standards ng judicial competence and integrity. Although kinikilala man po in every office of the government is a public trust and no position exacts greater demand on moral righteousness and uprightness of an individual than the seat in the judiciary. So, napakahalaga po ng moral righteousness kapag ka nasa judiciary branch ka. Next po. Yan, so Section 8 naman po, makikita naman po natin dito and 9, ang appointment po for the members of the Supreme Court and judges of lower courts. Na makikita po natin dito paano nga ba nag-a-appoint ng mga judges sa Supreme Court at judges sa lower court. So, number 1 po, wait lang. Ayan. Number 1 po, ang appointment po ng judges of the Supreme Court and lower courts, number 1, dapat po ay non-political process of selection and appointment. So, ang appointing power po natin alone is vested on the President. And ang mag-a-appoint po ay President of the Philippines with the consent po ng Commission of Appointment, with the consent po ng Commission of the Appointment in the Congress. So ito pong power nito ay kino-confirm po na sometimes, Noong 1973 Constitution po kasi, noong 1973 Constitution, ang nangyayari po kasi noon, ang appointment power po also nasa president pero kailangan po ng approval ng Commission on Appointments, no? So kinilala po nila na kailangan baguhin ito dahil minsan daw po ito ay nagiging source ng political haggling or horse trading. So ngayon po sa 1987 Constitution, nagkaroon po tayo ng non-political process of election wherein yung appointment power po ay vested sa president and meron po na silang members at yung process po ng selection appointment po of members of the judiciary ay binibigay na po ng Constitution. So ang gagawin po dito, kailangan po meron pong list of 3 nominees and from this list, ang president po ang mag-a-appoint at ito pong list na to, ng list ng 3 nominees na to, prepare po ito ng Judicial Bar Council. Ang president po ay hindi pwedeng mag-appoint ng kahit sino outside the list, but he can ask for additional nominees. And yung mga additional nominees na hindi na po kailangan ng confirmation from the Commission on Appointments. So the president shall issue the appointments of judges of lower courts within 90 days po from the submission of the list. Next po, pag-uusapan naman natin, ano ba yung Judicial Bar Council na sinasabi ko? So, ang Judicial Bar Council po, the Constitution itself, it creates a council na magpo-provide po this council, its composition, yung pag-appoint po ng members, yung terms po ng office nila, at pinaprescribe po ng Judicial Bar Council na to. Although it's not expressly mentioned, na ano ba yung mga qualification para maging member ka ng Judicial Bar Council, pero sila po yung nag-decide if a person po ba is talagang proven of competence, integrity, probity, and independence. So yung council po, sila po yung nag-i-ensure na yung mga nominees po na makakarating sa presidente natin ay pumapasok po sa re-recommend ng ating konstitusyon. Next po, sinasabi rin po sa Section 8 and 9 na exclusive authority po nasa JBC to recommend appointees to the Judiciary. So, ina-expect po dun sa Judicial Bar Council na in the place of the commission appointments, yung exclusive authority po to nominate justices and judges will further insulate the judiciary from political intrusion, result in the appointments only of person of proven competence, integrity, probity, and independence na magko-contribute po para patuloy na ma-improve ang ating administration of justice and ma-enhance po yung faith ng tao at sa respect po nila sa law. So, question po is, paano mo nga ba masasabi na ang tao ay with proven integrity, probity, independence, and competence? So, pagka ganung usapan po, pupunta po tayo sa rules of court. Wait in a while po. Ayan. Dito po makikita sa rules of court, yung nagiging pamantayan ng Judicial Bar Council sa pagdetermine whether a person po ba is proven po of competence, integrity, probity, and independence. So dito po dinidiscuss po ano po ba yung mga qualification po nila. Mula po sa kanilang public records, sinitignan po ito po, number one, example, yung competence ng applicants, paano ba din-determine. So tinitignan yung educational preparation, yung experience, yung kanilang government service, yung private practice nila. Next, pati po yung performance ng applicant, tinitignan po yung Judicial Bar Council. Next po, integrity. Paano ba din-determine ng integrity? Ano ba yung mga evidences of integrity? So, tinitignan po dito yung records nila, public records nila for their reputation, honesty, integrity, incorruptibility. Dapat walang kaso, walang kahit ano na makakapag-corrupt sa mga tinitignan to para ma-sure na meron yung mga judges na sound, moral, and ethical, pasok sila sa sound, moral, and ethical standards, nagkakaroon ng background check, nagkakaroon ng testimonies from different parties. So ayun po, makikita po dito sa rules of court yung iba't ibang pamantasan ng Judicial Bar Council in order to determine if the person po na mapasok po dun sa list na i-prescribe po nila sa President ay pasok po dun sa qualifications na binibigay ng Supreme Court. No? So bagamat ganun po, sabi daw po ng critics na kahit matindi ang ating safeguard pagdating sa qualification of judges, hindi daw po masusure na till now po ay talagang maiiwasan yung political affairs pagdating po sa appointments. So, ayun po yung sinasabi ng critics. It's up for us to decide whether it is not real or talaga bang impartial ang pag-appoint ng judges. Yan. Next po, for section 10 to 12, ito po ay represent ng aking kasama na si Marvin Copian. Although, sinabi niya po na hindi po siya Ayan. Naririnig po ba? Ito po. Represent po ito ni Marvin Copian, although hindi po kasi siya magiging present ngayon, pero nagbigay po siya sa atin ng recording. Pasabi na lang po kung naririnig.
Magandang araw po sa ating lahat. Pag-uusapan po natin ay ang section 10 to 12. The salary of Chief Justice
Naririnig po?
and of the Associate Justice of the Supreme Court and of judges of lower courts shall be fixed by law during their continued. Magandang araw po sa ating lahat. Pag-uusapan po natin ay ang section 10 to 12. The salary of Chief Justice and of the Associate Justice of the Supreme Court and of judges of lower courts shall be fixed by law. During their continuance in office, their salary shall not be increased. Yeah. Ang ating Chief Justice ay may initial annual salary of 240,000. Samantala, ang mga Associate Justice naman ay 204,000. So sinabing initial ang kanilang mga sahod dahil pwedeng tasan pa yun, no? At ipinagbabawal yung pagbabawas ng kanilang mga sweldo. So, Section 11. binabanggit na the members of the Supreme Court and judges of lower courts shall hold office during the behavior until the age of 70 years or become incapacitated to discharge the duties of their office. The Supreme Court shall have the power to discipline judges of lower courts or order the dismissal by a vote of majority of the members who actually took part in the deliberations and the issues in the case voted on. So, binabanggit lamang sa section na ito na ano yung conditions, no? Yung sa termino ng mga judges of Supreme Court and lower courts. And once na ma-appoint, no, matatapos ang termino ng members of Supreme Court when they reach the age of 70 years, no? Or if they become incapacitated physically or mentally, hindi na nila kayang kumpanan yung mga tungkulin. So question, paano kung hindi pa nare-reach yung 70 years old at may kapasidad pang gampanan yung kanilang duties sa office? Hindi ba sila pwedeng maalis, invoking the security of tenure? So the answer is no. Pwede silang maalis sa office in accordance with law. So ang members ng Supreme Court ay pwedeng ma-impeach. Ang House of Representatives ay have the power to initiate the cases for impeachment, while the Senate ang may kapangyarihan na magsigawa ng trials and decision. So kung matatandaan natin na-push yung impeachment ni Chief Justice Renato Corona. And as for the lower courts naman, pwede order ng Supreme Court, no, yung dismissal ng mga judges sa lower courts. Question din, pwede bang i-abolish ang isang office? Yes. Ang lower courts ay pwedeng i-abolish ng legislatura, no? But it should be done in good faith, meaning not for political or personal reasons. Gayun din, no, bawal magpasa ng batas, no, yung legislatura na in-organize, no, re-reorganize yung tenureship ng judiciary dahil iniwasan yung ganitong mga batas na magamit sa mga miyembro nito, no, as a trees, na the prohibition, no, seeks to prevent, no, the use of such law under the guise of reorganization to remove the members of the judiciary who refuse to kowtow to the powers that be. So, kanina nababanggit natin yung good behavior. So, kanina, no, the Supreme Court shall hold office during good behavior. So, what's the meaning of good behavior? Good behavior is conduct authorized by law. No? It also implies that the members of Supreme Court ay hindi nagpo-commit ng mga offenses na maaring ground for impeachment. Yun nga, as for the judges of lower courts, no, Congress has the power to prescribe the procedure, the causes of removal of the judges of the lower courts. But the Supreme Court, no, ay meron din jurisdiction na mag-order ng at kapangyarihan na mag-order ng dismissal ng mga judges na yun. Section 12. The members of the Supreme Court and of other courts established by law shall not be designated for any agency performing quasi-judicial or administrative functions. It is prohibited na i-assign ang members of the judiciary sa executive positions while returning their position in the judiciary. No? Gayun din, any agency, no, performing quasi-judicial or administrative functions. All silang i-appoint. So, ang mga rason ay such designation, no, violates the doctrine of separation of powers between the judicial and executive branches of the government. It may also compromise the independence, no, members ng judiciary. It may affect the performance of the judicial functions. Isa pa, kung na-assign sila sa ibang mga non-judicial or administrative functions, imbis na mabawasan yung mga kasong nakabimbing, baka lalo lang malagdagan yung backlog na hinahati. Ayan. That concludes the presentation. Thank you for listening po.
Next naman po is yung section 13. Na i-discuss naman po ng aking kagrupo po na si Princess. Wait lang.
Good afternoon, everyone. I am Princess Chara Palapus, and now we're going to proceed to the Section 13 of the Article 8 of the Judiciary Department. Nakapaloob sa provision na ito yung procedures sa pag-render ng decision. Kung ano man yung pagpapasya ng Korte Suprema sa anumang usapin na iniharap dito upang pasyahan ng en banc o sa division ay dapat mabuo sa pagkasanggunian muna or consultation. May tinatawag na certificate of compliance din muna bago ibigay ang isang usapin sa maestrado na magsusulat ng opinion ng korte. At may pirma dapat ng Chief Justice or Presiding Judge. The purpose is to avoid the practice of assigning a case to a justice for study and decision by him alone, the remaining justices affixing their signatures to the decision merely as formal routine. It is incumbent on the justices to take part in the consideration and decision of every case, whether the court sits en banc or in division, before any justice is given the assignment for the writing of the opinion of the court. In this way, the case receives the full benefit of the views and ideas of the justices. Any member of the Supreme Court or lower collegiate court who took no part or dissented or abstained from a decision ay dapat na mag-ibigay ang kanyang rason or katwiran for his non-participation, dissent or abstention. Next naman ay ang Section 14, no decision shall be rendered by any court without expressing therein clearly and distinctly the facts and the law on which it is based. No petition for review or motion for reconsideration of a decision of the court shall be refused, due course, or denied without stating the legal basis therefor. Yung meaning ng decision ay judgment rendered by the Court of Justice or other competent tribunal after the presentation of the respective positions of the parties in an ordinary criminal case or upon a stipulation of facts upon which the disposition of the case is based. Ang bawat decision ng korte ay dapat na klarong may paliwanag ang mga katotohanan or facts at kung saang batas siya nakabase. Ang korte din ay hindi na required banggitin yung mga factual or legal basis of its resolution granting a petition for review or motion for reconsideration of its decision. But it is certainly desirable in the interest of clearness and certainty that the court should state the facts and the reasons upon which the decisions rest. Otherwise, rights based upon them would have no concrete and lasting evidence. Next naman po ay ang Section 15. Nakapaloob sa provision na ito ang maximum periods for rendition of decisions. By constitutional mandate, ang iba't ibang korte ay dapat na makapagdesisyon o maresolba ang isang kaso within the following periods from the date of submission. For the Supreme Court, within 24 months, for the Court of Appeals and other collegiate appellate courts within 12 months unless reduced by the Supreme Court, for the lower courts within 3 months unless reduced by the Supreme Court. Ang time limitations na ito ay mandatory to ease up the clogging of court dockets at upang maimplementa ang karapatan ng isang tao sa mabilis na pag-usad ng hustisya. If ever man na-expired na yung applicable mandatory period, dapat pa rin na mag-decide ang korte without prejudice to the responsibility of the justice or justice concerned. Ang ikahuli naman po ay ang Section 16. The Supreme Court shall, within 30 days from the opening of each regular session of the Congress, submit to the President and the Congress an annual report on the operations and activities of the Judiciary. Nakapaloob sa provision na ito na dapat magsumite ng taunang report patungkol sa mga operasyon at aktibidad ng hudikatura. Dahil through these reports and recommendations na ginawa ng Supreme Court, the President and Congress may be guided in proposing or in the enactment of legislations affecting the courts and administration of justice. Yun lang po. Thank you.
Ayun po, that concludes po yung Judiciary Department, sir. Bali yun na sir yung last reporter po namin from the Judiciary Department. Sir? Hello po, sir.
Hello, good afternoon po. Mag-proceed na po kami sa presentation po ng Bill of Rights for Group 4 report po.
Okay. Group 4, are you now ready?
Wait lang po, sir.
Okay.
Na mag-share screen lang po. Nakikita na po ba yung screen?
Yes.
Kung ano,
Okay, good afternoon po. We are Group 4 and we are tasked to report on the Bill of Rights. So, let's proceed na po with the reporting. First, we will discuss the concept of Bill of Rights, which also known as the Charter of Liberty, and it was defined as Charter of Liberty because it includes declaration and enumeration of a person's basic rights and privileges as a protection against the state or by an individual. But meaning, ang mga karapatan na nakapaloob at pribilehiyo sa concept of Bill of Rights ay yung mga natural or kadalasang kailangan ng karapatan ng mga tao upang hindi sila i-take advantage or kaya nilang maprotektahan yung kanilang sarili laban sa kung anumang personal na vendetta ng Estado or ng sino mang individual na may kakayahan or may kapangyarihan. There are three classes of rights: the natural rights, constitutional rights, and statutory rights. Under the natural rights, this includes the rights of every citizen without being granted by the state, for they are given to man by God as a human being created to his image, so that he may live a happy life. So this is also known as God-given natural rights. So Under these rights, it includes rights to life, right to liberty, right to property, and even right to love. While the constitutional rights includes our rights conferred and protected by the Constitution. Since they are part of the fundamental law, they cannot be modified or taken away by the lawmaking body. And last is the statutory rights. Under statutory rights, it is provided by law, promulgated by the lawmaking body, and consequently may be abolished by the same body. So it may be abolished because ito yung mga laws na mag-exist siya or hindi apektado yung lahat. Pero malaki yung benefits niya kapag may karapatan na kabilang dito. Halimbawa ng mga karapatan na ito, yung right to receive a minimum wage, right to adopt a child, o yung pagkakaroon ng right to receive maternal benefits, paternal benefits, yung mga ganyan. Okay. Next, under constitutional rights, meron po tayong 4 classification. The political rights, civil rights, social and economic rights, and yung ating rights of the accused. So under the political rights, ito po yung mga rights ng citizen na nagbibigay sa kanila ng kapangyarihan na mag-participate. It's either directly or indirectly in the establishment or administration of the government. Kabilang nga po dito yung ating karapatan po na makaboto at makapaghalal ng mga public servant na sa palagay nating makatutulong sa maayos na pamamalakad ng ating administrasyon. Next is the civil rights. So under these rights, this includes enforcement at the instance of private individuals for the purpose of securing to them the enjoyment of their means of happiness. So they include the rights to due process and equal protection of the laws. Under Section 1, the rights against involuntary servitude and imprisonment for non-payment of debt or a poll tax. In Section 20, the constitutional rights of the accused and the social and economic rights, religious freedom, liberty of abode and of changing the same, and the right against impairment of obligation of a contract. So kabilang po dito sa civil rights natin yung freedom of speech, of expression, or freedom of the press, the right of assembly and petition, right to form associations, ayan. Likewise, ito po yung mga civil rights, they still partake of the nature of political rights when they are utilized as means to participate in the government. So as long as they are trying to help or they are giving suggestions or pagpuna dun sa government, kino-consider siya na participation sa administration ng government kasi for betterment pa rin naman yung involvement with civil education and civil rights. And next po is the social and economic rights. So this refers to the right which are intended to ensure the well-being and economic security of the individual. So kabilang po dito yung right to property and the right to just compensation for private property taken for public use belong more appropriately under this third category of rights. They are also provided in the articles dealing with the promotion of social justices, the conservation and utilization of natural resources, and promotion of education, science, and technology. So under political and civil rights can have meaning only if concrete measures are taken to breathe life and substance to social and economic rights, which include cultural rights. So dito po sa social and economic rights, bukod po sa pagkakaroon ng karapatan ng isang tao na magkaroon ng pagmamay-ari, papasok po dito yung mga cultural rights natin bilang mga Pilipino na kailangan maprotektahan. Kaya po may mga naipatupad po tayong mga batas kaukol po dito katulad ng pagpoprotekta sa mga mga ancestral lands. Ayan po. And next po ay yung rights of the accused. So they are the civil rights intended for the protection of a person accused of any crime, like the right against unreasonable search and seizure, the right of presumption of innocence, and the right to speedy, impartial, and public trials, and the right against cruel, degrading, or inhuman punishment. Okay. Mapapansin niyo po dito sinabi na this is intended for the protection of a person accused of any crime. Kaya nga po sinasabi sa balita, di ba? Kapag po merong mga suspect, kunyari sa SOCO o kaya sa investigador, hindi nila nilalagay na kung ano yung excuse me po. hindi nila nilalagay na naakusahan na yung na kasuhan na yung tao or napatunayan na nagkasala. Bagkus ito ay nilalagay lang na suspect or inaakusahan or salitang inaakusahan sapagkat may karapatan pa rin ang mga taong tulad nila na mapatunayan na ang kanilang kasalanan o kanilang hindi ay kailangan nilang sorry. Ulit. Karapatan ng mga inaakusahan na maipagtanggol ang kanilang sarili sa hukuman upang mapatunayan kung sila ba talaga ay nagkasala o hindi nagkasala sa ipinaparatang na kaso sa kanila. Yung dito naman sa right against unreasonable search and seizure, ito kabilang po dito yung mga illegal na paghahalughob ng iyong bahay o ng iyong mga kagamitan. Kaya nga yung sa isang Facebook video na in-upload, na dumaan lang siya sa newsfeed ko. Ang isang police or isang traffic enforcer ay walang karapatan na buksan. Alam niyo yung kapag merong checkpoint, di ba may mga checkpoint, tas may mga police, may hawak silang flashlight kapag kagabi. So, yung purpose ng flashlight nila kasi they are only intended to search the car outside gamit yung flashlight nila. So, imagine niyo tinututok lang nila yung flashlight nila dun sa loob nung sasakyan kung meron bang kahina-hinala dun, ganon. Pero other than that, wala na silang pwedeng gawin dun sa sasakyan like bubuksan or puwersahan na papalabasin yung driver ng sasakyan. So, ano na yun? Illegal na yun. Unreasonable search and seizure na yun. And next is the right of the presumption of innocence and right to speedy, impartial, and public trials. So, impartial and public trials, madalang yung pagkakaroon ng public trials sa Pilipinas kasi yung public trial man pala siya yung tunay na may gumawa ng krimen, maaaring makaapekto to sa kanyang moral na estado sa lipunan dahil may social media tayo na maaaring mas kumalat yung issue tungkol sa kanya at maaaring gawan siya ng hindi magagandang mga komento at iba pa. Now proceed po tayo sa state authority and individual freedom. So under state authority and individual freedom, meron po tayong apat, yung state as an instrument to promote both individual and social welfare, conflict between individual rights and group welfare, and balancing of individual and group rights and interests, and then the role of judiciary. Under the state po, kino-consider yung state po as an organization that exists to promote the happiness and welfare of both the individual and the group of which he is part. Hindi lang po siya nag-e-end by itself for the glorification ng life, ng liberty, ng property, or ng happiness of individual in all cases. It is also means of realization of the best life only by the individual for which the group may all at times, if necessary, be at stake. Dito po, kino-consider na yung liberty is a blessing without which life is a misery. So, parang sinasabi po dito na yung state is nagsaserve siya, hindi lang sa makapag-promote ng pantay na karapatan, kung hindi makapagbigay or makatulong dun sa social welfare ng mga tao, specifically sa Philippines. Kumbaga parang dapat maramdaman natin bilang mga citizens of this country na safe tayo and that we have a strong state and strong judiciary that will help us to have a better administration of government and syempre ma-secure kung ano yung mga rights natin as a person, as an individual, and as part of the government. And okay, so the doctrine of let's proceed now to the conflict between individual rights and group welfare. So, excuse me. So, dito po sa conflict between individual rights and group of welfare, so, as usual, hindi naman po natin maiiwasan na magkaroon ng conflict with individual to individual or group to individual or vice versa. So, the state in modern times, in modern times, will serve as an instrument to enable the attainment of greater happiness, progress, and welfare of both individual and society together. Consequently, in some cases, the individual must yield to the group, and in other cases, the group to the individual. So, for this reason, the Constitution creates a domain of individual rights and liberties which is protected from encroachments whether by individuals or group of individuals and even by the government itself. For the same reason, the Constitution provides expressly or impliedly that in certain cases, when demanded by necessity of promoting the general welfare of society, the government may interfere with its rights and liberties. So, the people must be strong enough to maintain the control over the government, and the government must be strong enough to maintain its existence and protect the interest of the people. So, pinaka gusto ko lang i-reiterate dito sa conflict between individual rights and group welfare, yung involvement ng Filipinos with the government should not be separated. Dapat magkasama siya kasi yung involvement ng people, yung mga criticisms of Filipinos to the government and the response of the government to these criticisms will help us again to have a better Philippines, because of course it will ensure the social welfare of not only few individuals but of course the society in all aspects. Okay, next part is the balancing of individual and group rights and interest. So under this, consistently with freedom, the rights and liberties of the individual be subordinated to the will of the government is a question which has assailed the very existence of governments from beginning of time. So the effective balancing of the claims of the individual and those of the community is the essence or indispensable means for the attainment of the legitimate aspirations of any democratic society. So there can be no absolute power. Whoever exercises it, for that would be tyranny, yet there can neither be absolute liberty, for that would mean license and anarchy. So balancing of individual and group rights and interest, very important na paulit-ulit or maipaliwanag na under state authority and individual freedom, wala dapat sino man ang magkakaroon ng absolute power, and kung sino man yung maghahangad or magtatry na mag-gain ng absolute power is magiging resulta or magiging tyranny na yung government. So sa ating history, alam niyo naman kung ano yung naging hangarin ng mga Marcoses during the martial law, and nagdulot siya ng tyranny. So kung babalikan natin yung mga nangyari sa kasaysayan ng Pilipinas, kung mawawala yung balance of individual and group rights and interest, nagkakaroon ng malawakang paglabag sa karapatang pantao. So sa Constitution natin with Bill of Rights, with the state authority and individual freedom, it is very important to emphasize the importance of individual and group rights and interest. It is not only the government that should be understood, but it is better to learn and of course, syempre mag-study din kung ano yung kalagayan ng mga tao, ng mga Filipino, ng citizens of this country, para sa ganon yung freedom and yung social welfare ng lahat ay masiguro na nasusunod or naipapatupad. And last po is yung role of judiciary. Under role of judiciary, in appropriate cases, rest primarily this all-important duty of balancing the interests of the individual and group welfare in the adjudication of dispute that is fair and just to the parties involved and beneficial to the larger interests of the community or the people as a whole in the exercise of the power of judicial review. So, sa role of judiciary, mahalaga na manatili yung ating hukuman, yung hukuman natin sa Pilipinas, sapagkat ito yung magsisilbing instrumento para matukoy kung naipapatupad pa ba ng maayos yung mga karapatan ng tao, yung karapatan ng mga grupo, ng mga individual, dahil sila yung mas nakakaalam nung pasikot-sikot ng konstitusyon ng Pilipinas. Okay, proceed na po tayo sa Section 1 of Bill of Rights. For Section 1 po, sinasabi dito na no person shall be deprived of life, liberty, or property without due process of law, nor shall any person be denied the equal protection of the law. Excuse me po. So, Under po ng Section 1 ay ipinapaliwanag po dito yung due process of law. Sa Constitution po natin, sinasabi dito na ang isang tao na deprived by the state of his life, liberty, or property provided due process of law is observed. So, ilan po dito sa mga proseso na kailangang sundin sa due process. Yung due process po, naririnig po natin to most nung panahon ng EJK, extrajudicial killings. Kasi wala siyang due process. Okay, ano po ba yung due process? So under the authority of a law that is valid, not contrary to the Constitution, nagko-comply po, okay, ito, yung procedural due process po ay yung method or manner kung paano ini-enforce yung law. Halimbawa, yung isang pulis ay nakaalam or may nagtimbre sa kanya na itong lalaking to, itong binatilyo na to ay drug addict. So, nung extrajudicial killing, kapag ganun yung nalaman ng ilang mga pulis, ang ginagawa nila is hinuhuli agad nila or yung iba sa kasamaang palad pinapatay. Okay, tulad ni Kian de los Santos. Pero dapat hindi ganun. Dapat nagpa-follow siya ng procedure na dapat meron muna siyang meron muna siyang letter from the from judge or dun sa lawyer. Meron siya dapat notice, ayun, due process. Requirement ng notice na it's either sabina or letter na iniimbitahan yung tao na yon para pumunta sa presinto or tapos dapat kailangan mababanggit sa kanya na you have the right to remain silent. Anything you say will be used against you. Yung ganon. Ayan. So, procedural judicial proceedings. Okay. So, in judicial proceedings, for the most part, procedural due process has its application in judicial proceedings, civil or criminal. So, dapat nire-require nito na substantive. Malagpas na ako. Okay. So, sa judicial, nire-require nito dapat impartial yung court dun sa with authority to hear and determine the matter before it. So, ayun, sa mga nililitis na sa hukuman, kailangan yung mismong judicial during the proceedings ay maging fair or madinig ng mabuti yung parehas na panig nung dalawang nililitis, yung nag-akusa at yung inaakusahan. So, jurisdiction lawfully acquired over the person of the defendant or property which is the subject matter of the proceeding. Opportunity to be heard given the defendant in judgment to be rendered after lawful hearing. So, there is a denial of procedural due process where an accused has been charged with an offense and convicted of another. Of course, the plaintiff has also a right to be given opportunity to be heard in his claim. So, kahit na yung isang tao na yon ay inakusahan ng pagnanakaw or ng robbery, ganyan, meron pa rin siyang karapatan na madinig yung sarili niya sa korte para mapatunayan kung nagkasala ba siya talaga or hindi. Okay, for administrative proceedings naman, hindi siya laging judicial process. In certain proceedings of an administrative character, notice and hearing may be dispensed with were because of public need or for practical reasons. The same is not feasible. Thus, an offender may be arrested pending the filing of charges, or an officer or employee may be suspended pending an investigation for violation of civil service rules and regulations. It is sufficient if opportunity is later given to the individual adversely affected to test the validity or propriety of the administrative action on appeal to superior administrative authorities or to the court, or even both. Okay, for substantive due process, nire-require po sa substantive due process na law in question affecting life, liberty, or property be a valid law. So, for example, within the power of the lawmaking body to enact and be reasonable in its operation. Thus, taking property for private use or without payment of just compensation offends substantive due process. So, dito po dito po sa substantive due process, sinasabi dito, property for private use or without payment is parang it offends substantive due process. Kasi merong existing law na dapat nagbibigay ka ng compensation for property na ginamit for private use nang walang bayad, nang may bayad dapat pero hindi mo binayaran. So, other example is kapag yung tax na ini-impose for private purpose constitute tapos hindi siya binayar, now offend the substantive due process. So ayan, kilala niyo naman yung mga hindi nagbayad ng buwis. Ayan. Next is persons protected, meaning of life, meaning of liberty, and meaning of property. So, pasadahan lang po natin ito ng mabilis. So, sa persons protected, ito po yung mga tao within the territorial jurisdiction of the Philippines without regard to any difference of race, color, or nationality, including aliens. So, kapag sinabi po nating aliens, kahit ano pa pong nationalidad niyan, so kung ano pa man pong extraterrestrial being po yan, basta within the territorial jurisdiction ng Pilipinas, ay kailangan pong protektahan niya ng konstitusyon ng Pilipinas. Sa meaning of life naman po, it is something more than mere animal existence. The prohibition against deprivation without due process extends to all the limbs and faculties by which life is enjoyed. So mamaya po explain ko furtherly yung wait lang. Ayun. Okay. So, sige, dito ko na sabihin. Sa meaning of life po, pag sinabi dito ng deprivation without due process extends to all the limbs and faculties of which life is enjoyed. Kunyari po, yung isang tao ay pinutulan ng daliri. So, kahit po yun ay kahit po hindi siya pinatay, pero binawasan or nag-cause ng pain or nag-cause ng something na difficulty dun sa tao na maipagpatuloy yung kanyang normal na buhay, yun po ay deprivation of life na. So, kunyari nabulag, ganyan, dinulag, or sinabuhay ng asido yung mata, ganyan. So, deprivation of life na yun. Kasi you have taken the opportunity or the capability of someone to see. Ayun. So, next po is meaning of liberty. So, as protected by due process of law denotes not merely freedom from physical restraint like imprisonment, it also embraces the right of man to use his faculties with which he has been endowed by his creator, subject only to the limitation that he does not violate the law or the rights of others. So, dito sa liberty, sa madalit salita, lahat po tayo ay may kapayapaan. Lahat po tayo ay mayroong kalayaan, pero lahat ng kalayaan na ay dapat may kaakibat na responsibilidad. Sapagkat ang pag-exercise ng yung rights of freedom is not a free pass para exercising your freedom is not a free pass para labagin mo yung freedom ng ibang tao. Okay. So, next po is the meaning of property. So, as protected by due process of law, may refer to the thing itself or to the right over a thing. The constitutional provision, however, has reference more to the rights over the thing. So, ito po yung sa meaning of property. So, ito po yung karapatan natin na magkaroon or mag-acquire ng mga property, ng cellphone, ng estate, or ng bahay. So, sakyan at iba pa. So, excuse me po. Okay. What constitutes deprivation? So, what the Constitution prohibits is the deprivation of life, liberty, and property. So, sa deprivation of life, it refers to not merely to the extinction of human existence. Ito po yung sinasabi ko kanina. It includes the loss of any of the various physical and mental attributes like limbs, eyes, brain, power of reproduction, which man must have to live as a human being. To be sure, some people would prefer death to living without eyesight or as a bedridden invalid. The right to life is the very foundation of all human rights. Without this right, all other human rights are empty and meaningless. Okay. Ito po yung sinasabi ko kanina. Sa deprivation of life, hindi siya naglilimita sa pagkitil ng buhay ng isang tao. Kapag ikaw ay nag-cause sa isang tao, kunyari, may truck driver na nakasagasa siya. So that is deprivation of life. Kasi nalungko yung taong nasagasaan niya, and he can no longer use his feet or yung kanyang lower part ng body para makapaglakad kasi nga you have caused him you have caused him something na na nakasakit sa kanya. Kung hindi po ako nagkakamali, sa United States po ata ito. Ang isang tao na nag-trigger sa isa pang kapwa-tao na mag-suicide because of mental illness ay punishable by law. So, kunyari merong may mag-boyfriend-girlfriend tapos yung boyfriend is clinically diagnosed with depression and sinabi niya na magpapakamatay na lang siya and such. Tapos yung babae, tinrigger niya na go, sige lang, ganyan. So, yung babae na yun is punishable by law, pero mag-undergo pa rin siya ng trial. Pero yung pag napatunayan na siya yung pinaka nag-trigger, bakit nag-suicide yung boyfriend niya is magiging punishable by law. Ayun, sure ko lang. Next is deprivation of liberty. So, to constitute deprivation of liberty, it is not necessary that a person be detained or confined. So, liberty need to be lost in its entirety to the extent that one is unduly prevented from acting the way he wishes to do. There is a diminution of liberty. So, example nito is a law which requires every parent to send their children only to public schools is unconstitutional as an unreasonable restriction on the liberty of parents and to direct education of their children under their control. Such a law deprives the parents of their liberty without due process of law. Okay. Yung isi-share ko po is personal take and personal ko lang pong perspectives. Isa po sa nakikita kong deprivation of liberty na meron tayo ngayon na batas na ipinatupad is yung terror law. Okay, wait lang. Search. Wala ko yung terror law. Okay. So, nilalaman nito, okay? Kahit yung pagtuliksa or yung pag-criticize mo sa gobyerno ay maaaring gamitin sa iyo bilang kaso dahil sa maaaring ikaw daw ay parang nangre-red tag, prone to red tagging yung ganitong law. So, kapag ikaw ay nag-criticize ng government, dapat bilang meron kang liberty and right to life, right to freedom of speech and everything, dapat yung mga ganitong batas ay kino-consider na ayusin na hindi siya dapat mag-overlap with the citizens' rights. Kasi tulad nito, okay. Okay, eto po. Sa letter H nitong Anti-Terrorism Act of 2022, nakalagay dito yung surveillance activities shall refer to the act of tracking down, following, or investigating individuals or organizations, or the tapping, listening, intercepting, and recording of messages, conversations, discussions, spoken or written words, including computer network surveillance and other communications of individuals engaged in terrorism as defined hereunder. So, maaaring ma-misinterpret or magamit itong vendetta ng ilang mga tao para maipakulong yung mga taong nagkikriticize sa kanila o yung mga taong gusto lang naman magkaroon or mai-practice yung kanilang freedom of speech. Ayan. May questions po ba so far? Okay, I will take that as a no. Okay. Next po ay deprivation of property. So, under deprivation of property, nakalagay po dito na with reference to property, it is not necessary that it be physically taken away from one entitled to it. There is also a deprivation when its value is destroyed, or its adaptability to some particular use or its capability for enjoyment is impaired. There is a deprivation of property without due process of law where the owner is constrained to devote it, wholly or in part, to public use without compensation as where carriers are required to furnish free transportation of persons or goods under certain circumstances, or where the value of an exclusive franchise is destroyed by government competition. Okay. Next po is meaning of equal protection. Under equal protection of the laws, it signifies that all persons subject to legislation should be treated alike under like circumstances and conditions both in the privileges conferred and liabilities imposed. So, it should guarantee na hindi po nire-require na yung tao o yung mga bagay na magkaiba man ng estado ay dapat tinitreat ng law as parehas or same. So, dapat kapag yung tao na napatunayang nagkasala at kinulong, dapat parehas sila ng mga normal or mahihirap na tao na kapag ikinulong, walang aircon yung bilibid. Ayan. So, dapat hindi po ganun. Indeed, inequality will result if the law will treat them alike as when different net incomes, like yung 100,000, tapos yung isa 10,000 lang. Tapos itatax mo sila with the same amount. So, hindi siya pwedeng ganun. Kasi magiging unfair siya kung kunyari, so 100,000 ng tax mo nakukunin ay 10,000. Tapos yung isang tao or employee, ang kita niya lang ay 10,000 tapos 10,000 din yung itatax mo sa kanya. So that's unfair. It discriminates against some and favors others when both are similarly situated or circumstanced. For example, also an example is a law imposing professional tax of 100 pesos on lawyers or any profession residing in Manila and 75 on lawyers residing outside Metro Manila is within the prohibition as it is patently discriminatory and unreasonable. Since they are still similarly situated, their places of residence being totally irrelevant to the amount of tax should be paid. Okay. For reasonable classification permitted. So no violation is committed as long as the classification is reasonable, not arbitrary or capricious, and all within the same class are treated like. Thus, there is no denial of the protection where under the law. Okay, so kasama po dito yung mga reasonable grounds ng tao or ng property, like in foreign corporations. So they are made to pay higher amount of taxes than that paid by domestic corporations. Second is yung may mga certain professions po like sumo wrestling na limited to persons lang ng male sex. So, malamang po kaya po yung sumo wrestling ay is limited lang for male sex kasi syempre yung physical and yung meron kasing biologically differences yung male and yung female na hindi applicable sa female yung ginagawa or yung bubugan sa sumo wrestling. And third is yung certain privileges for leaves and shorter hours of labor extended to women by reason of the physical structure and maternal functions of women are not extended to men. So yung privileges like maternal benefits or yung maternal leave ng mga babae, hindi siya extended to men. Pero as far as I know, merong ilang kumpanya na nagpa-practice ng paternal benefits sa mga mag-asawa para kapag katapos manganak nung nanay, for a month or 2 months after, yung father naman yung pwedeng mag-file ng paternal leave para siya naman yung magbabantay dun sa baby nila. Okay, number 4 is the preference is given to Filipino citizens as against aliens in the list of public market stalls. And number 5 is different professions are taxed at different amounts. And 6 is employment in factories of children under designated age is prohibited. So, child labor is prohibited. Okay, the scope of the guarantee. So number 1, the prohibition containing the guarantee of equal protection is a restraint on all the organs of the government and on the subordinate instrumentalities and subdivisions thereof and on the 3 inherent powers of government, police power, taxation, and eminent domain. The guarantee is available to all persons, aliens, or thus included so or private corporations in so far as their property is concerned, but municipal corporations being creature of the state cannot invoke the protection. It does not extend to rights which are political. The state is not prevented from restricting the enjoyment of political privileges like the right to vote to such classes of its citizens as it may see fit. And lastly, it is also not intended to enforce social equality while all persons are equal in worth, they are not equal in all things. So, okay. Ayan na po. Next po is Section 2. The right of the people to be sure in their persons. Secure po ito. Secure. Type pa lang to. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures of whatever nature and for any purpose shall be inviolable. And no search warrant or warrant of arrest shall issue except upon probable cause to be determined personally by the judge after examination under oath or affirmation of the complainant and the witnesses he may produce, and particularly describing the place to be searched and the persons or things to be seized. Okay, so let's proceed with the meaning of search warrant and warrant. Okay, a search warrant po is an order in writing issued in the name of the people of the Philippines na sinasign po ng isang judge and directed to a peace officer. So pag peace officer, mga police po natin, commanding him to search for certain personal property and bring it before the court. Okay, so if the command is to arrest a person designated, for example, to take him into custody in order that he may be bound to answer for the commission of an offense, the written order is called warrant of arrest. Okay? Ulit po. Pag search warrant, order in writing po siya to search for certain personal. So, maghahalughog lang, magsa-search lang sa isang lugar or hahanapin lang yung lokasyon ng taong ito. Pero kapag warrant of arrest, eto na po yung command o yung pag-uutos na hulihin or dalhin sa custody in order yung taong iyon na nakalagay dun sa warrant of arrest. Okay? So, yung scope ng protection sa persons, it applies to everybody, kagaya ng sinasabi kanina. Anyone, everybody na within territory ng Philippines. And yung sa houses po, kabilang po dito, yung protection is not limited, pero kasama hanggang yung sa garage, yung warehouse, yung shop, yung store, yung office, and even yung mga safety deposit. So, it does not extend, however, to open spaces and fields belonging to one. Tapos sa papers in effect naman, it includes sealed letters and packages in the mail, which may be opened and examined only in pursuance of a valid search warrant. Okay. Next po is, kailan ba nagiging unreasonable ang isang search seizure? So in general, all illegal searches and seizures are unreasonable while lawful ones are reasonable. So a search for seizure made without a search warrant is not necessarily illegal, and one made under a search warrant is not necessarily legal. What constitutes a reasonable or unreasonable search or seizure in any particular case is purely judicial question. So only courts are empowered to rule upon, determinable from a consideration of the circumstances involved if meron siyang requisites for valid search or valid search warrant or warrant of arrest. So ito po yung mga sinasabi ko kaninang due process. So kapag po mag-search warrant or warrant of arrest, so dapat yung letter is issued upon probable cause. And second, probable cause must be determined personally by the judge himself. So, dapat judge muna po yung una. Pangalawa is madadetermine yung existence of probable cause made after examination by the judge of the complainant and the witnesses he may produce. And then the warrant must particularly describe the place to be searched and the persons or things to be seized. The law prohibits the issuance of search warrant for more than one specific offense. Ano po ba ibig sabihin ng probable cause? Yung probable cause po is when such facts and circumstances antecedent to the issuance of a warrant sufficient in themselves to induce a cautious man to rely upon them and act in pursuance thereof. So it presupposes the introduction of competent proof that the party against whom a warrant is sought to be issued has performed particular acts or committed specific omissions violating or given provision of our criminal laws. So yung probable cause po, sa madalit salita, dapat merong ginawang krimen or may violate na law or criminal law yung isang tao para determine yung existence ng judge doon sa probable cause or doon sa inihahatol na violation doon sa batas na nilabag. Okay. So, next po is yung sufficiency of affidavit upon which warrant is based. So, test of sufficiency affidavit. So, the true test of sufficiency of an affidavit to warrant issuance of a search warrant is whether it had been drawn in such manner that perjury could be charged, thereon affiant be held liable for damages caused in case declarations are found to be false. Kunyari po, naglabas po ng warrant, issuance of warrant. Dapat po, yung gagawin ng mga peace officer na inutusan or commanded by the judge ay hindi po sila maninira ng mga gamit sa property, kunyari, or hindi nila sapilitan or intentional na sisirain yung mga bagay or yung mga makikita nilang property dun sa loob ng bahay, ganun. Lalo na kung mapapatunayan po na yung lugar kung saan naghalughog or nag-search warrant ay wala naman pong kinalaman talaga doon sa krimen na inihahatol na inaakusa sa kanya. So, second po yung basis of affidavit. Excuse me po. The affidavit must be based on personal knowledge or information. It is insufficient if it is based on mere information from other people or belief or on mere hearsay. So, katulad po sa history, yung basis po ng affidavit for search warrant or warrant of arrest ay hindi po dapat base lang sa sabi-sabi. Hindi po siya nakabase sa chismis, hindi po siya nakabase sa kwento-kwento lang. So ito po ay dapat sinisiyasat, tulad po ng ginagawa natin sa history, nagko-corroboration din po sila dun sa basis ng affidavit kung totoo ba siya or kung nagtutugma ba yung sinasabi ng witness 1, witness 2, witness 3, at ng iba pang mga evidences na makukuha nila during the trial or during the examination ng probable cause. Okay, next po is sufficiency of description. Okay, kapag po merong warrant of arrest, yung description po ng lugar na isa-search warrant, sufficient po dapat. Dapat po nakalagay po dito yung yung pinaka-specific identity ng place intended. Like, for example, building number 123 Rizal Avenue, Manila, ganyan. Kasi kung sasabihin mo lang po na, ay, dun yun sa may tondo. Masyadong malawak yung tondo. So, dapat specific po yung nakalagay doon. Kapag po yung witness ay mag-share ng information about sufficiency of description. Pangalawa po, for person, a warrant of arrest for the apprehension of an unnamed party upon whom it is to be service of is void except in those cases where it contains a description of the person or such will enable the officer to identify the accused. Like, for example, Joe Doe as Joe M. Villoso was identified without difficulty. Ganyan. Minsan kasi yung ibang mga inaakusahan, meron silang mga nickname or also known as mga ganyan. So, sa property description naman, dapat nire-required na insofar the circumstances are ordinarily allow, it has been held that whereby the nature of the property to be seized, the description must be rather general. It is not required that a technical description as this would mean no search warrant could be issued. So, rights against unreasonable search. Okay, almost done na po tayo. Right against unreasonable search and seizure personnel. So, dito po kabilang yung proper party to invoke rights. So, the legality of search and seizure can be contested only by the party whose personal rights were involved. Consequently, seizure. Kunyari, yung recent na issue sa Facebook na yung babae nakatira siya sa isang condo unit, tapos bigla siyang pinasok ng mga barangay tanod habang wala siya doon sa condo unit. Yung condo unit is legally owned by her husband, pero hiwalay na sila. So dito sa property party to invoke right, yung right doon for legality ng search and seizure ay nandoon sa asawa niya. Kasi nasa asawa niya or nandun sa babae, kahit hiwalay na sila, separated lang sila, hindi pa ata divorce. So kung hindi pa sila divorce or hindi pa annulled yung kasal nila, may rights pa rin yung asawang babae dun sa property ng asawa niyang lalaki. Pero yung pinsan na naabutan dun sa condo unit ay walang karapatan na magkaroon ng walang karapatan na mag-raise ng question whether has been unlawful search for seizure. So dapat yung asawa or yung mismong may-ari na nakapangalan dun sa mismong condo unit. Okay. Number 2, right subject to waiver. Without a proper search warrant, no public official has the right to enter the premises of another without his consent for the purpose of search and seizure. So dito, right subject to waiver, dapat kagaya din nung it does not admit of doubt, therefore yung search or seizure cannot be considered as unreasonable and thus offensive to the Constitution if consent be shown. For this immunity from unwarranted intrusion is a personal right which may be waived either expressly or impliedly. So dito dapat yung yung public official Okay. So dito po, sa no public official has the right to enter the premises of another without his consent for the purpose of search and seizure. Kailangan po, kapag merong magiging unreasonable po yung search and seizure kapag yung public official na yon ay pumunta sa premises ng isa pang public official tapos naghalungkay o nagkalkal doon ng gamit nang walang kaalam-alam yung official na may-ari ng office na yon. So magiging unreasonable yon. So kahit na magkaibigan pa sila, if very personal or legal yung mga pinakailaman na gamit, yung mga sinearch doon. So that is unreasonable. So when search and seizure may be made without warrant, kailan ba magiging okay yung search and seizure kahit walang warrant? Okay? Okay. It is in the following instances. Number 1, where there is no consent or waiver. Number 2, where search is an incident to a lawful arrest. Number 3 is in the case of contraband. Dito po sa where there is consent or waiver. Ito po yung sa search and seizure na to, like for example, sa isang casino, kunyari, merong nagtimbre doon na meron daw mga drugs. Meron daw mga nagaganap doon na drug trade. So, dahil po good afternoon po, sir.
Yes.
May class na po kami sa STS po. Nag-send na po ng link yung prof po namin. Okay lang po ba kung tuloy na lang po ulit natin sa next meeting po sa Saturday?
Yes. So, group number
4 na po tayo. Dito po nag-stop sa search and seizure po without warrant.
Okay. So, can you please send the attendance for today's meeting?
Okay po, sir. Sabihan po namin yung secretary po, nag-attendance naman po siya. Isa-send na lang din po namin within today po sa inyo.
Okay. Thank you.
Po, sir. Thank you po.
God bless.